As we had talked about before, the slides that you're going to see today are going to kind of walk you through the model contract as it currently stands and hit on a number of different issues, both those that are required under the statute and other provisions that I think you may want to consider just in terms of coming out with a very strong contract. So I'll start with, as I make sure that I'm going through here correctly. Let's see. Sorry, I've got to find my way of doing it here. Yep. So the goals today for the presentation, and I really do like to think about this more of, rather than it's just me speaking to you, as we go through, please feel free to jump in and ask questions, and if there are things that seem unclear or you have done it differently and you want to point that out, that would be terrific. So the goals for the presentation today are, number one, I think it's important as you begin the process, whether you are starting before you have a contract, whether you're reviewing your contract, or whether you have a contract and you're saying to yourself, okay, did we hit all the pieces of it, to know and understand the purpose of a charter contract. And I think a lot of people, certainly people who are not all in your positions, who've worked really closely in it, just don't get the whole concept of what is the charter contract. And I think it's important to know that, because I think you'll have a better understanding of what should be in there if you do. To know the basics of the charter contract, to identify some common governance issues that can affect the charter contract. How are you set up? Who is your authorizer? I have been running into some situations where it's almost a hybrid organization, where you have one private organization, one private school, one public charter school, all run by the same nonprofit entity, and that makes things a little bit difficult at times too, and changes things in the contract. Learn today what's required by statute to be in the charter contract. You'll hear me say in just a few minutes that there are lots of rules and regulations in 118.40, which is the charter school law in Wisconsin, that you have to follow as a charter school and as an authorizer. But that doesn't mean all of those provisions need to be into your charter contract. There are specific provisions that have to be in the charter contract that are set forth in the statute. And so hopefully by the end of this, you will understand which ones are required by statute and others which you may just really want to give some serious consideration to including. Recognizing other provisions that can strengthen your charter contract. I think we're trying to hit on a number of issues today that either at times you don't think through when you're contracting with your authorizer, but sometimes there are provisions that I have dealt with over the years with charter schools and had to at least do kind of a on-the-fly provision or amendment to a charter contract. So I have tried to think through those and include those in the model contract as well. And then consider some additional information to be included in the charter contract. What else might you consider? So to talk about just in terms of the purpose of the charter contract, as you all know, 118.40, which is the Wisconsin Charter School Law, is meant to allow charter schools to develop and have flexibility and discretion in determining what their educational methods and instructions look like. It gives charter schools the ability to set hours, to set their calendar, to have, for example, what someone just talked about, project-based learning versus, typical learning in your bricks and mortar school. It really gives charter schools a lot of discretion in the method that they are going to use to teach students and how they're going to do it. But what happens with that is, because the charter school law exempts charter schools from the provisions in 118 through 121, which are all those rules and regulations that apply to public school districts, you have to use the charter contract to kind of put those back in. The charter contract puts back in those rules and regulations, if you will, between the authorizer and the charter school. So essentially what it says is, we may not be bound by what's in 118 to 121, but we are going to be bound by what's in this charter contract between the authorizer and the governance board. So if somebody wants to see how our school is going to run, what our educational mission is, making sure that our teachers are licensed by DPI, how do we deal with special education, they can go to the charter contract essentially and see that those things have been addressed in there. and there are provisions that talk about what the authority is, what the responsibilities, the obligations. So it's a way that it almost replaces what's in a lot of those 118 to 121 statutes. So I think when you think about it in terms of that way, it gives you a better idea of what is really the purpose of the charter contract. So there's a number of specific provisions or purposes that I've identified today. Defining the mission and methods used by the charter school. You may have a charter school that is focused on STEM learning. It may be direct instruction. It might be project-based learning. But it's important for both parties to know what that is in terms of the mission and methods used by the charter school. Clearly defining the roles of the authorizer and the governance board. I can't tell you how many times I get calls from authorizers and charter school governance boards, because I have represented both over the last number of years. And they say, you know, here's the situation that came up. We never thought about this. Does our payments to the charter school include the payment that we make for lunch? Does that include, are we required, and does that include all of our technology provisions? So making sure that you're defining the roles in the authorizer and the governance board. Delineating the authority and obligations.
Are you going to get into that more, or is there a place where people could look to kind of think like through, oh, we didn't think about lunch delivery or busing schedules, or like?
A lot of this stuff is addressed in these slides, Sarah, and in the model contract, but that is a good question, is that would it be helpful to have sort of a list of things that may have come up over the years that I've either addressed in the contract or that others have questions about, does it need to be in there? But both of the things that you have talked about in terms of lunch and transportation, those are addressed in the contract. Yeah. So we're going to be going into a lot more detail. This is just kind of an overlay.
This is your overview, right? Yeah. I wonder too if like in the future we could dig up some example roles and responsibility delineation. Like if some people might have like a one pager, like these are the jobs of the school board or authorizer, these are the jobs of a governance board. Like I think our governance board trainings get into that a little bit. But even just like a, you know, quick like cheat sheet, I think would be a cool thing for us to come up with too.
Okay, right. Yeah, no, that's a great idea. Yep. To protect the authorizer and the governance board. Certainly what a contract is, obviously it's an agreement between two parties. It sets out their authority, it sets out their rights, it sets out the obligations, and the provisions in there are meant to look out for the interests of both the authorizer and the governance board. I have done a lot of work with charter schools that are authorized by school districts, and just as a caveat, our firm represents a number of school districts in the state of Wisconsin. So certainly my work has been heavier on the side of school districts than it has been the charter school governance boards. But because there's such a close relationship between the two, I end up working with both pretty often. But protecting the authorizer and the governance board, when you are talking about a public school district, that is the authorizer, and the charter school is an instrumentality, and even if it's not an instrumentality of that public school, the authorizer is is a board of elected officials that have duties to the public, and they have duties to have a fair amount of oversight over the public dollars and how they're spent. What I have seen over the years is that when an issue comes up, for example, I'll give you just an example, if the charter school is not abiding by the requirements to be non-sectarian in the statute. So if they are purchasing religious materials or something like that comes up, and DPI has an issue with that, the Department of Public Instruction, they will go to the charter school and address it with them, but ultimately the buck stops at the school district, because the school district is the authorizer. The state aids are going from the school district to the charter school. And so in terms of that relationship, I often find that the charter contract is really helpful in making sure that the interests of that publicly elected body in terms of the school board are considered and protected in the charter contract. On the flip side, it's the same thing with the governance board. The governance board is an independent entity that takes on a lot of responsibility and liability when it enters into these contracts. So to try to think through what provisions may provide protections to both an authorizer and a governance board. You'll see that as we go through, and I'll kind of point them out. And then to develop procedures. How do you evaluate the charter school? What happens? When can a district or an authorizer revoke a charter grant? And then what happens if that charter school does close? You know, you have charter schools that close. Does the contract provide for that? What happens to your student records? What happens with debts that you might owe? What about things that you have purchased with funds that have come directly from the district? What if you have things that have been purchased from your booster club or your PTO? How does that all resolve? So trying to develop some procedures and include at least some model procedures for those events, and also to kind of put that in your mind as these are things that need to be addressed when you are contracting. Where does the charter contract fit in the process? Again, kind of an overview question here. And that question I do get quite a bit, because people will say, I haven't started on the charter contract yet. Where does this all fit in? Certainly you do some planning ahead of time, right? You determine that you're going to set up a charter school, whether that be a district authorizer that says we think a charter school should be in our school district, or whether it be a set of parents who say we'd really like to have a charter school with focusing on STEM learning. But whatever that planning process is, you're going to identify the authorizer, what that structure of the school is. And then you are going to have to put together your organizational documents, because remember, when you're talking about a charter contract, that charter contract is a contract between two entities. One of them is the authorizer, the other is the entity that is going to be responsible for the charter school. And so DPI certainly takes the position that has to be a separate incorporated entity. So in order to have that entity contract with the school district or with OEO under a 2X contract, it's important that you put in place all of your corporate governance documents, your articles of incorporation that you would file with DFI, and put together your bylaws, which would indicate or which would set out the process that your organization is going to follow for purposes of electing boards of directors, holding meetings, taking action, dissolving, all those sorts of things. So you want to have your organizational documents in place, because that really will define who is contracting with the authorizer and what that's going to look like in terms of responsibilities. Then I would say you would move into your charter contract. Now, this is obviously a really bare bones list. There's so much more, as everybody knows, that goes on here, but I just kind of wanted to give you an idea of where I have seen it fit nicely into the process. Once your charter contract is signed, then you have just myriad of things to be thinking about in terms of what happens after that. You need policies. Obviously, if you're going to enter into any subcontracts, maybe there are leases. Maybe that would be required even before you enter into your charter contract. But your teacher contracts, insurance, those sorts of things, you want to make sure all of those are in place. To be honest, in the 2X contracts, where I have represented, or I am representing the charter schools in the 2X process, those subcontracts, teacher contracts, insurance, and things had to be finalized and provided to the authorizer before the charter contract was signed. So those are things that may come a little bit before that, but that will just depend upon what type of charter school you are. The basics of a contract. When you talk about, you're interested in knowing whether or not you have in there the important things in the contract, you have to identify the parties. What's the consideration, meaning what's the benefit to the authorizer and what's the benefit to the charter school? So what is the benefit that the charter school governance board is getting, and what is the benefit that the authorizer is getting? What are the terms of the agreement? We'll talk about those at length coming up here. What's the term of the contract? Being sure that you are within that 5-year maximum that the law allows, but what is the term? Does it allow for renewals? What does that look like? And then what constitutes a breach of the contract? Laying out very clearly in the contract what actions or what events would constitute a breach, such that you could either be given an opportunity to cure if you're the governance council or the authorizer, or a breach such that it would give the authorizer the ability to terminate, or the governance council the ability to terminate the contract. So those are the just the basics of the contract. Charter governance issues that come up, just in terms of things to think about that might affect your contract, is who is your authorizer, right? In terms of If you are a district authorized, who's contracting with the district? Is the governance board incorporated? Are they a 501c3, a separate 501c3, which means that they have exemption from federal tax laws? How does that governance board retain autonomy? Are they going to have all of the powers and be the board that is going to be determining curriculum and education, or are you subcontracting that out to an educational management organization that will be doing that? And how is that going to work with your governance council and that other body? The non-instrumentalities, who's the employer? Is it your governance board? Are you contracting that piece of it out? How is that all working? Can affect what your contract is. The 2R and 2X charter schools, who's contracting with the authorizer? The 2X charter schools, what I have found, and what's been an interesting situation, as I had said, is I've kind of seen these hybrid models where you have schools that are already schools, but they are private schools, and now we're going to kind of open an arm of a public charter school, and that presents issues when you're talking about what that contract looks like, and in terms of just things under charter governance that might affect is, what do your articles say? What do your bylaws provide in terms of governance board members? What do your policies say? So with respect to the board. So there are particular issues that come up just in terms of how you have structured your charter governance in terms of who has responsibility, who's in charge, are you an instrumentality, things like that that really do affect the provisions in the contract. So moving directly then into the model contract, I want to make clear this is a model contract. It is not a mandatory contract. Hopefully you will find it helpful in certainly identifying the provisions that are required in the contract by statute, and hopefully identifying some other provisions that are provisions that you at least might want to think about and clearly define things in your contract above and beyond what's required by the statute. So you will see it includes the required statutory provisions. It provides other suggested provisions to strengthen the contract. And ultimately, the most important point, it can be modified, it can be amended, it can be tweaked, it can be changed. You can throw the model contract out and start over and do the contract that you, in a manner that you think is a better way. But I think the model contract, the purpose that it certainly does serve is it gives you a nice template to start with in terms of making sure that you are hitting the provisions you need to hit and thinking about the things that I suspect, just from working with charter schools, you're going to encounter as a charter school and as an authorizer. Preliminary issues in the contract, I'm just going to go here. Definitions. I think this oftentimes gets overlooked because it's not sort of that really rote process of things in terms of contract drafting. I'm not a business lawyer per se, but I do a lot of contract drafting for schools and other nonprofit organizations. But definitions is important to have in there. And the thing about definitions, and what you will see down here, is this is just these are just suggestions that I've pulled out of other contracts I've done. But why they are important is because they will define the material terms in your contract, right? So if you are talking about who the parties are, you want to define who those two parties are to the contract. Maybe there are more than one party to the contract. You want to define those terms in the contract that when you see them capitalized in the contract, they always have the same meaning. So applicable law, you would define applicable law to be all Wisconsin law that applies to charter schools, including 11840. It would be, federal law that applies to charter schools. It may be IDEA in Section 504. All sorts of laws that may be applicable to charter schools. You would want to indicate in your definitions that applicable law, and when we use that, means X, and it generally will mean all state and federal law that may apply to charter schools. So you want to have definitions in there so that you are ensuring that when you are reading those terms in the contract, everybody is on the same page and knowing what those mean. Article 2, parties, authority, and responsibilities. Again, be really clear and state who the parties are. Who is contracting? Who has the oversight? Who's going to be running the charter school? Who's going to be responsible for implementing the duties and responsibilities of it? And so you want to go through and make sure that you have a provision in there that kind of it's almost an introduction to the rest of the provisions, but it really sets it up so that when you start the contract, you know who the parties are, who has responsibility, and who is accountable for the obligations that are going to be set forth in the contract. On that section 2.4, I also would suggest putting in a provision if you are going to be allowed, the authorizer is going to allow you to potentially establish additional charter schools. I would indicate that in your contract so that's clear up front. And it may be that upon written approval of the district or the other authorizing entity, if it's a 2R entity. There are some provisions in the charter school law where you are not allowed to open additional charter schools, but those are in limited circumstances. So I would put a provision in there that talks about whether or not you're allowed to open another charter school if you're the governance board. It's still sticking in the Article 2, the party's authority and responsibilities. I would explain in your charter contract what the charter contract, who's your authorizer and what it's authorized by. Charter school, as you can see in 2.5, it's authorized pursuant to an agreement under WSStat 660301 between the following districts. There are a lot of charter schools out there that are authorized by several districts. So it may be in smaller areas, like one of the listeners was talking about. A number of school districts may come together and enter into what's called a 660301 agreement, which is set out in the statutes as to what exactly has to be in it. But they enter into a 660301 agreement to authorize the charter school. And so because the students from those districts can enroll in the charter school without having to go through the open enrollment process, you are going to want to identify in your contract what school districts those are, so that the charter school and the district, it becomes very clear as the students from those other districts can enroll in the charter school without having to go through the open enrollment process if the charter school is not in that student's district. It'll also, I would say, address that whatever district will be the fiscal agent for the charter school pursuant to 660301. Also, I included these provisions where charter school authorized pursuant to an agreement with CISA. There's a provision in the statute which allows the district to enter into an agreement with CISA. You want to include that in there. Or it may be authorized pursuant to an agreement with an American Indian tribe or whatever particular band. The point of all of these is just set out in your contract how this charter school and the authorization came to be. So that is very clear in the contract and it's set up right at the beginning. I think sometimes if you do that in the beginning of the contract, that also drives what needs to be in the contract. You will start to think of things that need to be into the contract just by recognizing, okay, this is the kind of charter school we are. We have several districts that have authorized us. How does that drive some of these provisions in the contract as we move through? So I think it's important to do that.
Tess, can you go back just for a second? I wanted to ask you about the CISA agreement, because it's a little bit different where a CISA is not an authorizer listed in the legislation, but I know that some schools are operated by CISAs. Could you explain that a little bit, or
Yeah, I mean, I'll be completely honest. I've never worked with a school that has had a authorizer enter into an agreement with a CISA. But one of the provision in the statute that deals with it is under the sub 3, which is the contracts, and it talks about the fact that one or more school boards can enter into an agreement with the Board of Control of a CISA to establish a charter school. Essentially, the CISA would take it would be essentially the charter school governance board. So the district would be entering into an agreement with the CISA to operate the charter school.
Okay.
Now, CISA may authorizer, but the authorizer is the district. And that's the same with the 60301. Even though they've entered into an agreement, the district is the authorizer. In each of these, the district is the authorizer, but they have the ability to enter into these agreements with a CISA and an American Indian tribe. Does that make sense?
Yeah, no, I think that makes a lot of sense.
And I don't know. I'm not sure how that looks when the charter school is established pursuant to an agreement with CISA, but I would assume it looks very similar to where it is authorized pursuant to an agreement with a contract with the governance board.
Yeah, I could see that being beneficial for smaller districts who, like one of our attendees today was saying, in such a rural, small area, it really is hard to kind of muster up enough people to serve on those governance boards and to have the expertise to manage the funds and attend the meetings and all that. And so if you could rely on your CISA to sort of do some of that work on behalf of the school, I could see that being a great service.
Oh, I agree. Yeah, definitely. I think the CISA would be obviously very helpful just in terms of ensuring teachers, policies, procedures in place. I mean, I can imagine that would be helpful.
Thank you for going on that tangent with me. I just think it's a really interesting thing that we don't see pop up very much, and I'm curious about it. So, all right, moving on.
Right. I have not worked with them, and I would be interested. It would be something we could ask DPI, Nico, or LaToya about in terms of how many of those, if any, are out there in terms of and seeing what their charter contracts look like. I think that would be helpful.
Okay, thanks.
Looking still at the terms required under 11840, the name of the legal entity seeking to establish the charter school. This seems like a no-brainer, but what I have discovered is that particularly when you may have a couple of entities, like if you have an overarching 501c3 organization or nonprofit that has private schools and also has a public charter school, well, is it really your public charter school governance board that is entering into the contract with the authorizer, or is it really that overarching organization that enters into the contract with the charter school and then gives authority to the governance board to run the charter school and make decisions and take on debt and take out loans and things like that? So the name of the legal entity seeking to establish the charter school, it isn't a no-brainer, particularly if you have a bit of a complex corporate governance structure. You really want to think through who is it that, in fact, that is actually contracting with the authorizer. The name of the person who will be in charge of the charter school and the manner in which administrative service is provided. I would say it probably doesn't make sense to actually include the name of the person because you don't want to be changing the charter contract. But what it means, I think, in terms of that is there going to be a charter school administrator? Is there going to be a charter school principal? Just so you're clear in terms of who it is that's going to be in charge of the charter school. In the event of a non-instrumentality or 2R or 2X where the school district or the authorizer is not in charge of hiring the employees, you may want to include a provision in there that talks about approval of proposed successors to that position. So for example, if OEO, which is the University of Wisconsin, under 2X, if they are all gung-ho and entering and starting this charter school because the head of the charter school is somebody that they really have a lot of faith in and they're excited about, and now a month later that person is a different person, you may want to have a process built into the contract for some kind of approval process of proposed successors. A description of the educational program of the charter school. You're going to want to have a general discussion of the educational program of the school, particularly when you're talking about charter schools and you're talking about instructional methods that might be distinct from the general public school instructional methods, like we talked about earlier. Methods that are based on individual learning principles, core knowledge sequence, STEM, e-learning, project-based learning. You're going to want to define those in your charter contract so you know what the education program is. And then I would suggest, and this has really come out of, we had some contract, we talked about these model contracts with some of the stakeholders that have been involved in charter school law a couple of months ago. And one of the issues that came up was by an authorizer was, what if a charter school decides halfway through that they don't want to do STEM anymore and they're going to do something else? Or we noticed that they really don't have a distinct educational program and now it looks more like what we are teaching in the public schools. How do we make sure that the parties are adhering to the educational program? So to include that the governance board shall adhere to the educational program set forth herein and to promptly notify the district in the event it determines to change that. And that provision goes on in the model contract, you will see, but a provision to deal with that. On the flip side, what happens if halfway through the contract the district says, look, we don't like the STEM, instruction and curriculum. We're going to actually have our teachers be trained in more of the core knowledge sequence and start introducing that into the public or into the charter school. Well, a provision that says the district shall agree to allow the charter school to implement the educational programs set forth in this contract, and then you'll see in the contract that it goes on to say, and if there's any change, it has to be by mutual agreement of the parties. So that sort of takes care of or protects the site of the charter school, so that if they have an educational program that the governance board has entered into this contract to provide to students, a provision that doesn't allow the district to unilaterally turn halfway through and change that. So governance board and district, it gives protections, kind of both of them, when you talk about what the educational mission is. Section 3.4, the methods the charter school will use to enable pupils to attain the educational goals. A description in the ways that they will enable students. Are you going to be looking at academic skills and knowledge? Are you going to be evaluating vocational skills? It may include some key components of charter school curriculum, the roles of the teachers, the tools. This really is one of those provisions that gives the charter school governance board or the entity that is running the charter school a lot of discretion to sort of set out what the methods used are. I have seen charter contracts that go into unbelievable detail on this, 3 or 4 or 5 pages of it all. And then I've seen charter contracts that may have a page of it that just say, look, here's the general way we're going to ensure that our students meet these educational goals. We're a project-based learning system. We're going to do assessments. The student will do self-assessments and, on and on. So that really this is kind of where the expertise of those individuals from the charter school and the expertise from those individuals comes into play and is most helpful here, because obviously if you have lawyers drafting this agreement or you have people drafting it that are outside of that group, we are not the experts in the education piece of things. So this is really your opportunity to explain how you're going to reach those goals. Also, I would address in this provision, section 3.5, the method by which pupil progress, sorry, I guess I'm going on to the next one here, the method by which pupil progress will be attained. Well, there are certain standardized tests that you do have to administer as a charter school. Those look a little different if you're a district authorized charter school versus a 2R or a 2X charter school. But be sure that you know what those required standardized tests are in the statute. And then if you are a district authorized charter school, are you going to be held to district-wide assessments? Is your charter school going to be involved in any sort of specific assessments that the district offers? If so, and if that's something the district is going to require as an authorizer, you want to make clear that you address that in the contract. Section 3.6, the governance structure of the charter school, including the method to be followed by the school to ensure parental involvement. Okay, so this is really where it talks about what is your governance board. What is the entity, the incorporated entity that's going to be contracting or likely to be contracting with the authorizer. So you want to indicate that it has been organized, the charter school is going to be directed by an independent governance board, organized by a Wisconsin non-stock corporation, if it's applicable. You'll see that there are other ways to do it. Right now I'm dealing with a governance board that's actually an LLC. So there are different ways to organize as a corporate entity. This provision talks about, have they obtained the status of a federal tax exempt organization? How are they dealing with their directors' terms? The number of directors and directors' terms shall be set forth in the governance board bylaws. I find it to be helpful in there so that you are ensuring that these things exist and that this governance process, it has moved along in terms of incorporation, bylaws. It gives the kind of just more structure and more assurance that the school governance council will function as its own sort of corporate entity. When we talked about this, I'm going to deviate just for a second, but when we talked about kind of the whole charter school process and this large federal grant that came, the large federal grant that DPI is managing, in the stakeholders meeting, we talked about the fact that how do you develop and create and continue charter schools that are going to continue into the future. I have watched over the last, like, probably 8 years, there have been explosions of charter schools here and there, and oftentimes what happens is when those charter schools are started by a small group of parents who are all members of the governance board, and it's in a small area and there is not a lot of support beyond that, it's hard to sustain that. Because when you are a small group of parents all on a governance board, that's a big commitment, a voluntary board where parents are looking at what the curriculum is, they're dealing with staff issues, all sorts of things. It really becomes a difficult kind of model to sustain. So I think with the influx of the federal grant money, I think DPI's goal is to really put some processes in place that that ensure a really solid governance structure in terms of a governance board. And I think that goes to making sure that there is a solid structure in place. Is it an organized entity? Does it have bylaws? Where does the board come from? You can see here the board may include, but it's not limited to, parents or guardians, community members. You may include other individuals that you can think of. I would say do not include students. If you're going to have a student, make them advisory members. They can't enter a contract if they're a minor anyway. No more than a minority of the board's members will be employees of the charter school or employees or officers of the district. That is a requirement under Wisconsin law. And if you're going to receive the federal grant money, as you can see at the bottom, if you are a district authorized charter school receiving the federal charter school program funds, you can have no members of the charter school governance board be employees or officers of the district. Honestly, as a conflict of interest, just as a matter of conflict of interest, I would suggest, if I am advising a charter school, I say you don't want employees or officers of the district on your charter school board. First of all, I personally think you can't have officers of the district, and when you talk about officers, a board member of the district. You can't have a board member of the district on a charter school governance board and then have that board member contract with itself as it contracts with the authorizing entity. I cannot tell you how many times I've seen that happen, and I oftentimes, I get a lot of pushback on that for some reason, because oftentimes board members are the ones who are really interested in seeing these charter schools move forward. But for conflict of interest reasons, you don't want to have board members on your governance council. I would also argue that you don't want to have employees on your governance council. Although, yeah, Sarah, I'll jump to you in just one second. Although I know that having employees, a lot of charter school governance boards have employees, because sometimes those employees are the ones who really drive what the curriculum, the methods of instruction, and kind of that strategic plan of the charter school. The difficulty when you have an employee is that they just inherently have somewhat of a conflict of interest. If they sit on your governance board, you're certainly going to want provisions for when evaluations come up, renewal decisions, anything that may affect that employee's interest. They are not going to want to. You are not going to want them to vote on those issues. Sarah, did you want to jump in?
Yeah, I just wanted to, for those here who are, well, non-instrumentalities, I suppose, would still fall under those same district provisions, but the independent charter school, independently authorized charter schools, would they also not want members of their authorizers institution serving on their board?
Well, they certainly wouldn't want any members of the board of the authorizing entity.
But for the same reason of that institution.
I think you would have less of a conflict, certainly. I mean, you definitely would have less of a conflict, because an employee of the author of a 2X or a 2R authorizer is not going to be an employee of the charter school. So I don't think you run into those same issues. When I'm thinking through who that would be, like at the 2X level, I just don't see a place for that. Yeah. But that may not be on the governance board, but that may not be the case with 2R charter schools. If you have an authorizer that's a bit more involved in the actual charter school. But right now with the 2X charter schools, it may be happenstance that you have a university employee who's also an interested parent and going to be on that charter school board, but I don't see that there is someone at the university level that is dealing with the charter school that would want to be on the board.
Yeah.
But I don't know, the issue could come up. I think you're right in pointing out, though, that the conflicts, that conflict issue doesn't come up like it does when you're talking about an employee from the district.
I
would incorporate, I would incorporate the articles and bylaws of the organization in your contract. I would say that the articles of incorporation and the bylaws are incorporated herein, so that you can, it's right with your contract as to what those articles are in terms of the governance board, how the governance board is set up, and how their board is going to run. Section 3.6, the governance structure of the charter school, including the method to be followed. Again, I would suggest making clear in this part of the contract what the governance board has autonomy and decision-making authority over. I would set those things out. We have talked about this a lot at the stakeholders level, and I see it a lot in my work with charter schools that are district authorized. It is a very odd relationship statutorily between authorized school districts and charter schools when the school district is the authorizer, particularly when that charter school is an instrumentality of the district. And it's a weird relationship because, as you know, charter school governance boards need to have autonomy and decision-making authority. The statute requires it to a certain extent. Obviously, the federal funds require it. But again, when those funds are being given to the charter school governance board from the school district, and they are a percentage of whatever state aid may come in, per pupil state aid may come in, there necessarily has to be oversight on behalf of the district authorizers. So it's an odd relationship when you talk about a K through 12 authorizer, and particularly when the charter school is an instrumentality of the district. I think it's hard to really truly be autonomous as a governance board in those situations. And I will say, just working with charter schools, it's all over the map in terms of what school boards, what they do allow a governance board to have autonomy over. So it kind of spans the gamut of different things I've seen. But if you are, I would suggest that that you set those things out. The provision should really reflect, and I think DPI hopes that it will, the principles and standards established by the National Association of Charter School Authorizers. And that if you look up the NACSA principles and standards, you can find those online. And that includes consideration of what the charter school's authority over the educational programming, the budgeting, the staffing, and the scheduling of the school. This provision is required for schools receiving federal charter school program funds. It is not required for schools that are not receiving that, but I think it makes sense to have that in there. So when you talk about what authority do they have, you might hit on, do they have authority to, make budget expenditures? Do they have authority to seek and spend their own grants? Do they have authority to set the calendar and their daily schedules, the curriculum, the instruction? I certainly hope so if you're a charter school governance board. The policies and procedures that are applicable to students, the facilities where they want to be located, and do they have the ability to enter leases and do their own marketing, etc. Now, the statute does address this, and the statute 3.6C does indicate that the governance board has to have powers necessary to carry out the terms of the contract. And those include receiving and dispersing funds, securing insurance, entering into contracts. You can see all of those. I would include this provision in your charter contract. I think this sets out pretty clearly the requirements of the statute, and essentially it mirrors the statute, but also really makes both parties think and realize what the authority is of the governance board. So when you see this as an authorizer, you say, okay, wow, they really are their own separate entity. They have the ability to receive and disperse funds. They have the ability to get their own insurance and enter into contracts. Maybe those are their educational management contracts with a company. And so they have the ability to acquire real property. So I think having these directly into your contract really makes both parties realize, okay, these are some provisions that really give the governance board some real authority. Section 3.7, the qualifications that must be met by individuals to be employed by the charter school. Obviously, this deals with your employees. This changes whether you are an instrumentality a bit, or a 2X or a 2R charter school. You want to set out in here, I would set out whether you are an instrumentality of the district, and if you are a district authorized charter school, you have to have this in your contract. If you are a 2X and 2R, obviously this is not going to be included in your contract, or in the 2X contract that one of the ones that we drafted, we said both parties agree that the charter school is not an instrumentality of any school district, and therefore no school district is the employer of any teachers. If you are an instrumentality, the teachers and staff are employees of the district. They have to employ the personnel for the charter school. It's required by statute. If the school board determines that it's not going to be an instrumentality, the board cannot employ any personnel for the charter school. It isn't a they can if they want to, but they don't have to. It is a they cannot employ the personnel for the charter school. Now, I'm going to go off here just for a minute because this is a little bit tricky. I recently got a question on the FAQs that we'll talk about at the end that asked about, well, we are a non-instrumentality charter school, and we would like our employees to be able to stay in the WRS, the Wisconsin Retirement System. If we don't call our teachers employees of the district, but the employees remain on the district's payroll, and we subcontract those employees from the district. Does this provision really apply? Are we violating this provision, or can we do that where we subcontract so that they stay on the district's payroll, stay in the WRS, but really we're the employer of them? And my response, which is just my response from looking at all of the law, is that I think you call a spade, is that if you have an employee who is on the district payroll, getting unemployment comp from the district, getting other benefits from the district, no matter what you call them, subcontracting does not take you out of this provision. I think at that point they are still personnel of the district. They're still employees of the district. That said, I have two thoughts about it. One, we do kind of violate this provision sometimes when the district, in a non-instrumentality charter school where the district may provide special ed services or a special ed teacher or an OT/PT to come over and provide occupational therapy in these special times. Are they violating that? I guess to the literal terms of the statute, maybe. I don't know that they are the personnel of the charter school. In that situation, in those limited circumstances, I would argue that the spirit of the statute means you can't employ the full-time teachers of the charter school. So that's the first thought. The second thought is that Nico from DPI, Nico Mitnott, pointed out that there may be a way for a charter school that is a non-instrumentality to have their employees remain in the Wisconsin retirement system, separate and apart from this provision and how you draft this. When the law changed in, I think it was 2016, to require governance boards to have all of those powers that we just saw. I'll look for this here. The powers to levy taxes, borrow money, and that's actually not true. But when the law changed to be sued in its own name for the governance council to enter into contracts, when the law changed to give the governance boards more specific authority under the law, there is a question as to, because they are their own independent legal entity, they may be able to have their employees be in the WRS. I will say I don't really know the final answer to the question. I know that Nico has followed up with ETF to see if it's possible. They've indicated that may be a possibility with the authority that governance boards have been granted now by the statute. but I don't think anybody's come to a final answer. So I think if that is an issue for you and you are trying to figure out a way for your employees to be part of the Wisconsin retirement system, I think one of the things I would do is I would contact ETF and see if there is a possibility there's a process for that. So I just don't think you can have that happen by calling the employees something different and subcontracting them all to the district. If they're on the district's payroll, they're getting their unemployment comp, their taxes, or things like that paid by the district. I think, obviously organizations can do what they want to do. I think you'd have a tough argument that they were not employees of the district.
Mm-hmm. Plus, you lose the freedoms that you gain by separating your teachers as not employees of the district. You'd lose some of that freedom if you were to try to then recontract with the district. So I think the idea of the school, handling its own staffing and then trying to, sort of sign up with WRS as its own institution sounds like a really great path. So I'm curious to see how that plays out.
Well, and I agree, Sarah. I do think you lose some of it. I suspect the idea would be to have some district staff and then the ability to hire others that are not, so that you're not bound by all of the employees of your charter school or district staff, but it's a way to kind of piecemeal it.
Yeah.
But I think that I do think you run the risk of violating that provision. I would include some additional provisions in the section 3.7. I've included them here just as other things you might think about. The number of administrators, teachers, and other staff will be determined by the governance board and approved by the district, so that the process is kind of a collaborative process, at least, where, and this would be in an instrumentality charter school, let me make that clear, where the process is collaborative, so that you in fact give the governance board some authority and some part in the process of hiring the teachers. Recommendations for renewal of administrative and teaching contracts will follow the required statutory timeline. So when you are a public school district, you are under certain timelines in 11822 for non-renewal, and if these are district employees, they will have to go through that same statutory timeline. That isn't the case when you are a 2R or 2X charter school, because you aren't subject to those provisions. But for instrumentality charter schools, all administrators, teachers will be employees of the district. The district and governance board will collaborate in the hiring process. The governance board will conduct the interview process and recommend candidates for final approval of the district. And all employees of the charter school must be approved by the district and the governance board, trying to give the governance board some part in that process, in terms of, if the governance board says, here's a slate of 10 teachers that have all been trained in the Montessori method, and this is who we would like to have hired at our school, and the district board of education says, nope, I think we're going to put these other 10 people in here, none of whom have had Montessori training. I think governance boards are concerned by that, or even, substituting individuals. So all employees of the charter school must be approved by the district, and the governance board could be a provision you put in there if you want to ensure that you have some control on both sides. These provisions should talk about evaluating the performance of the administrators and the teachers and give a process for that. And the second bullet point there, upon approval by the district, the charter school employees shall be allowed to substitute X days of professional development specific to the educational program implemented by the charter school. So one of the issues that came up is that when a district only has so many professional development days, and those days are all spent in professional development that is completely unrelated to the instructional methods of the charter school, it's difficult for those charter school staff then to receive that training. They have to do it outside of their contract period. So this is just a possible provision that you may want to think about, in terms of, if you can come to some agreement with your school district that maybe a couple of the professional development days could be sort of choice days by the charter school teachers, so they could participate in professional development in the area of which they're teaching. Okay, 3.8, the procedure the charter school will follow to ensure the health and safety of the pupils. Again, this is one of those provisions I've seen sometimes a lot, sometimes little. You could talk in here in terms of the charter school will ensure that it follows all laws regarding mandatory reporting. It'll ensure physical, mental, and emotional health of students that may provide, if you were going to provide a police liaison or an SRO at the charter school. Are you going to have emergency nursing services? You can put that in. You'll be doing drilling on evacuations, tornadoes, intruders, obviously with the home safety, the funds for safety, the training. Maybe you spell that out a little bit more clearly, but the procedures that you will follow for ensuring that. 3.9, the means the charter school will achieve a racial and ethnic balance among its pupils. Again, I have kind of woven in the non-discrimination statement into this and indicated that the charter school will be distributed, the information out will be distributed through newspaper articles, mailings, and that the hope is that you achieve a racial and ethnic balance that's reflective of the district school age population. So that population, if your charter school sits, you know, in Madison, that may look different than if your charter school is sitting out in Verona. But that is what the statute requires, is that you take means to ensure that you're getting the information disseminated to all of those potential students in your district in an effort to achieve that balance. The requirements for admission to the charter school and then the admissions lottery. This is a big one for charter schools. I would include provisions in there that the charter school is open to all students in whatever grades you're open to, and it's open in two ways. One, to those students who reside in the district, or this may look a little different if you're under a 660301. You may want to say those students who reside in the districts identified in section 3.1 or whatever it may be, or 2.5, or are enrolled in the district pursuant to the open enrollment statutes, or the statutes that allow non-resident students to be in the school. Here is, I would say, the provision with regard to the 660301, charter schools open to all students in grades blank who reside in the following districts or are enrolled in the district pursuant to the open enrollment. 2X and 2R, the open enrollment provisions, obviously are not included. The one piece is that, as we go through, I think it's on the next slide here, the question that has come up to some extent is, if your enrollment period as a charter school ends before the opening of the open enrollment period for the district, which is in February, how do you do that in terms of if you receive applications from individuals that are outside of your district and your enrollment, you go through the lottery, and that lottery is done prior to the time that the open enrollment period is, how do you deal with that? And so we have a provision in here that talks about that piece as well. But what kind of the recommended, or at least an idea of some language that might be in this part of the charter contract. The governance board will set enrollment limits by December 1 and submit them to the district by January 1. The helpful piece of this is, if you are a district authorized charter school, your boards will be setting space decisions for open enrollment at their January board meeting. And so this way, though, your school boards will know potentially how many spaces exist in your charter school. If the number of enrollment applications that you receive exceed the enrollment limit, you have to select the students on a random lottery basis. So you have to go through a lottery. The statute does, though, allow you to give preference to certain students. Those are students who are already attending the charter school. And there are other preferences as well in there. It allows you to give preference to children of the charter school founders, governing board members, and full-time employees. But those, the number of those children given preference can't be more than 10% of the charter school's total enrollment. They have to be cognizant of that. So the charter school will give preference to pupils and siblings of pupils who are already attending. Open enrolled applicants who meet the eligibility requirements and select the charter school as a preference will be placed in the charter school if space is available. So that provision is put in there so that when a student is open enrolling into a district, the law says you can't, you can ask, but the district is not required to place you in any particular school. They place you by where is there a spot in a grade. So if you have 5 elementary schools and each of them have a spot open, the district is not required. If you say, I only want to be in Sugar Creek Elementary, the district isn't required to put you into that school. They can fill the spots as they see fit. This gives a little bit of agreement between the district and the charter school to say, hey, district, if we do get open enrolled applicants who select us as a preference, you will put them in the charter school if space is available for them. If a student who selects the charter school as a preference is a student with a disability, I would include language to address that, because that student is going to have to be placed in that charter school, that particular school, by the IEP team, or they are going to have to look at that placement and determine what the appropriate placement is for that student. So when you talk about a student who has an IEP, it does require a few additional steps. You can have a waiting list, and if you want to include language in there that you will maintain a waiting list for students who are not selected in the random lottery, and that'll be open to a certain point to fill the seats. And I would also include a provision that states that an open enrolled applicant's admission to the charter school will be contingent on the student's enrollment in the district. So I'm going to take a step back because I think all of this gets really confusing. So if you have an enrollment period in your charter school, and enrollment goes from January 1st to January 31st, all the students apply, you hold your you get more than you can handle, you hold your lottery, you fill all the seats in your charter school, and 5 of those students who are taking a spot are students that are open enrolling from a different district. You can't promise those students that they will be given admittance to your charter school until they are admitted into the district via open enrollment. So even though your decisions are made on January 31st, you have to wait for that open enrollment period to end to see if that student is enrolled in the district through open enrollment. Hopefully that makes sense to all of you guys. Sarah?
Yep, I see we have a couple questions popping up in the chat, so I'm just gonna read them quick, and then you don't have to. Yeah, don't worry about it. I'll just keep an eye on it. So it's one quick question is just if a student is already open enrolled into the district in the years prior to the charter school, and then they want to switch schools to then be in the charter school of that district, do they need to, do they get to be in the first lottery or the second lottery in this case? Like, are they counted as a current district student, or are they counted as a new open, you know?
They are counted as a current district student. They are counted as already enrolled in the district. So you would not have to take that next step. There is one exception to that, is if your district has a requirement that open enrolled students reapply for open enrollment during their period of time in the district, because the open enrollment statute allows districts to say, allows districts to have one time that students are required to reapply. So in Verona School District, where I'm from, if a student open enrolls in kindergarten, when they start into middle school, they have to reapply for open enrollment and get in through the open enrollment system to stay enrolled in the district. So if that timing overlaps in a weird way, then you may have to, although I think Nico and I talked about the fact that you may even be able to consider them a currently enrolled student in the district because they are currently enrolled in that school year and they wouldn't lose their enrollment until the next one. So I would say if the issue comes up, I would seek some, and you're confused about it and that weird little timeline exists, I would say ask about it or seek advice of your counsel. But as a general rule, if a student is already open enrolled in the district, you don't have that you can consider them already enrolled in the district for purposes of being a student to apply to your charter school. That makes sense?
Yeah. I know the sibling thing has come up before too, that if a sibling is graduating and then their younger sibling wants to attend the following year, there was a school where I think it was unfortunate, but the sibling didn't get in because the older sibling was already going to not be attending that following year. So you really have to read closely, like if they're a current student versus enrolled in the same year. Does that make sense?
Yeah, the statute, and that's under the sub 3 of the statute. It says, a charter school other than a 2XM shall give preference to siblings of pupils who are enrolled in the charter school. So if you are making your enrollment decisions at a time when their sibling has not yet graduated, I'd argue you could fall under that provision, frankly.
Oh,
and they could
interesting.
be considered a sibling of a student that's enrolled in the charter school.
Mhm.
Now, fast forward a year and that sibling has graduated, I don't think you can fall under the sibling enrolled in the charter school. And I don't think that the exceptions give you any ability to give preference to
Like alumni.
students who, alumni.
Yeah. Yeah.
What about in the first year, if you have siblings of different ages and you're doing
Both applying.
for every level?
And both are.
I was thinking about, do you start with the older siblings and then go down? Like, does it matter? Because are they considered enrolled? I guess the question is, are they considered enrolled as soon as their name is drawn for the lottery?
Yeah, that's a good question, and that I don't know the answer to, Lynn. But that is a good question. I mean, I think
if you draw out the older kid, then do you also then go draw out the younger kid, because then they're automatically
right
in?
Still,
I mean, it makes sense to me, except, and I know that in the open enrollment statute, there's a process for that when you are picking a sibling. The only thing my only just off the cuff response would be that picking a student's name in the lottery and offering them a spot in your charter school does not make them enrolled. Right? They may enroll, but they also have the ability to say no thank you. And then you could be in a position where you're offering a preference to siblings when those students are not yet enrolled. I don't know the answer. I think that's a good question maybe to talk through with Nico. It seems to me that if you're going to accept one sibling in there, the next one should get some preference. But technically under the statute, I don't know.
Right, exactly. You want to do the right thing, but we're dealing with pretty small numbers in year one, and it could be all fine. Or
right. Yeah.
Right.
Thanks. That's right. Really, that's
I think. Yeah, that is interesting. I think that probably comes up frequently, to be honest. I mean, I think with new charter schools, it probably does come up a lot, or at least with charter schools who have too many students. Okay, I'll keep going here. 3.11. I'm going to make sure I'm moving through. I'm going to try to move through these just a little bit faster so that we can get through them all. The audits of the financial aid and programmatic operations of the charter school, I have included some sort of standard language. The procedures for disciplining pupils. Some charter schools adhere to the disciplining procedures of the district if they are a district authorized charter school. Others have their own discipline policies of the charter school. This is one of those things that, certainly just ensure that you know that the district, if you're district authorized and a charter school governance board, that everybody is on board and on the same page of what those policies are going to include. Remember that you do have to adhere to, I would suggest you adhere to the, NACSA talks about this, not expelling or counseling students out. In addition, discipline policies, if you are disciplining a student who has special needs, so if you are disciplining a student who has an IEP or a student who's under Section 504 of the Rehabilitation Act, there are specific provisions for discipline related to those students. So you cannot, if you are going to set forth your own discipline policies as to exactly what your discipline looks like, you're going to have to pay particular attention to individuals with disabilities because you are required by federal law to follow a process for those students. If those students commit a violation of your code of conduct that would result in their expulsion, you cannot expel them from the school if their conduct was because of their disability, essentially, if it was a manifestation of their disability. So there are processes. This is one of the things I have found that has been tough for charter schools, both with governance boards that are non-instrumentalities and 2X and 2R charter schools is that this is an area of the law that a lot of people are unfamiliar, and these are some really specific and some very technical procedure and substantive requirements under federal law when you talk about students with disabilities. So just be sure you have processes in place that ensure your compliance with those laws. Obviously, you have to have a provision in there that says there are alternatives for students who don't want to attend your charter school. I thought that was a no-brainer decision or no-brainer provision until I had a school district that was all charter schools. It had no non-charter schools, so that was a little bit more interesting. Description of the school facilities and the types and limits of the liability insurance. I would specify here a specific description of the school facilities. Where are you? Is it owned by the district? Is it owned by another entity? Are you leasing it? So that's clear in here. I would also talk about specific types and limits of insurance. Do you have like a commercial general liability policy? Do you have auto policies because you have charter school transportation, umbrella, workers' comp, errors and omissions? Be really specific and at least give what insurance both parties know is going to be required. You also might want to consider an indemnification provision where the parties indemnify each other depending upon the circumstances. So that I included a sample one of those in the contract as well. The liability of the district, that is just essentially says you aren't agents or representatives of one another, so you're not going to bind each other by making decisions moving forward. You don't have that authority to bind each other except as expressly provided in the contract, the statutory provision that's required. Okay, so those are all the provisions that are required for district schools and really all charter schools with the exception of a couple of provisions that don't apply to 2R and 2X. These are provisions that are required in the statute for 2R and 2X schools, and I'm just going to kind of go through these somewhat briefly. A requirement that the charter school governing board adhere to specific annual academic and operational performance standards developed in accordance with the performance framework of the entity with which it's contracted. So you're going to want to talk about academic and operational performance standards. What are the students going to be required? How are they going to be required to perform? What are those standards? And I would look at those NACSA principles and standards again when you're developing them. The Office of Educational Opportunity with the University of Wisconsin has online its model contract that it has used, and it does have some really, really specific academic and operational performance standards in there, which would be really helpful for other 2X schools to take a look at, or other 2R schools, I guess, as well. Corrective measures the charter school governing board will take if the charter school fails to meet performance standards. What are those correctives? Do you have an opportunity to cure? How long? What do you have to do? Do you have the ability to, you have to include in there whether or not you've been given authority to open additional charter schools. Section 4.4, the methodology that will be used by the governing board to monitor and verify pupil enrollment, credit accrual, and course completion. Since if you're running a high school, you're going to have to know if students have the requisite credits or course completions in order to graduate. So it should provide some detail regarding monitoring, recording attendance, measuring of student progress, those things. A requirement that the authorizing entity have direct access to pupil data. So one of the certainly that the OEO charter schools or the 2X charter schools, one of the benefits of that is that if these institutions are doing research, educational research regarding whether it be instructional methods or any type of other research, you're giving them access to the pupil data. But in addition, they also have access to that pupil data, so they know that you are complying with whatever requirements under the law that you would be required to comply with. The one thing I will say is ensure that, and I think I added one of these provisions in here, that to the extent your charter school provides any charter school records to the authorizing entity, so if the authorizing entity is the Office for Educational Opportunity and you provide student records to them, you need to make sure that that the authorizing entity agrees to abide by student records laws and confidentiality laws and does not disclose such records to any third party except as required by law. So when you are a charter school, if you're a 2R or a 2X charter school and you you are running your own school and you are now collecting records on students, you are bound by the provisions of confidentiality that you would see in FERPA and Wisconsin People Records Law. So you're going to want to ensure that you know what those requirements are, what the rules regarding confidentiality and disclosure are, and that you have processes to deal with that. A description of the administrative relationship between the parties to the contract. So what are the services that you're going to provide? A requirement that your charter school governing board hold parent-teacher conferences at least annually. They want to make sure that there's, teacher conferences. A requirement that the charter school governing board provide data needed by the authorizing entity for purposes of making the report that's required under 11840. So what that means is that every year the authorizing entity, whether it's a district or a 2X or a 2R charter school, has to provide to the superintendent of public instruction certain information about your school. And so in order to do that, they need that information. So you have to be able to, provide it to them. A requirement that that your board participate in any training provided by the authorizing entity. So if the authorizing entity says, hey, we're going to require you to go through mandatory reporting training, you have to do that. A description of fees that you'll charge the charter school governing board. So the 2X and 2R charter schools have worked things out a little differently. Some of them say we will take 3% of whatever your amount is that you receive from DPI, but no more than 3%, and then we'll look back, and if we didn't use all the 3% in terms of our administrative costs, we will repay that back to you, and but there will be a cap on it. So there's a number of ways to work it, but essentially it's the consideration that's given to the 2X and 2R authorizers. So if you're the Office for Educational Opportunity at the University of Wisconsin, and you're spending money on administrative oversight of a charter school, it's a way for the charter school to pay OEO for their services in that oversight and in their administration of the charter school. Okay, exemptions from requirements. These are now moving into provisions that I have just identified that may be helpful for you to consider, and I think that are helpful to have in there. I would set out I would say that you're going to take all allowable exemptions under the state law. There's a provision specifically in the charter school law that says charter schools are not subject to, except as otherwise noted, subject to any of the provisions in chapter 118 to 121. I would make clear that you're going to take those exceptions. Then I would also be clear with the district as to what policies, if you're a district authorized charter school, that you are going to be exempt from in terms of district policies. Other terms and conditions, well, and I just say that these, again, are just provisions that I would suggest. I would be clear in there that your students and staff will adhere to a specific code of conduct. I would talk about the fact, or just be clear that you are non-sectarian in your programs, admission policies, employment, curricular materials, and operations. I would make clear you're not going to charge tuition. Again, you can't do these things under the charter school statute, but these statements aren't required to be in your charter school contract. I would just include them. For virtual charter schools, I would include these provisions. I would suggest going a little bit further in terms of the requirements that you see under 11840 sub 8, which are specific to virtual charter schools, and ensure that the charter school governance board and the authorizer know that your instructional staff will be responsible for improving planned instruction, diagnosing learning needs, these sorts of things. You wonder why these are required, or these are set forth in the charter school statute, because when virtual charter schools first started, there was a real kind of a knocking of heads between the Department of Public Instruction and virtual charter schools that were essentially Department of Public Instruction saw as public funds going to homeschooling. And what the Department of Public Instruction has made clear is that there has to be a real delineation between homeschooling and virtual charter instruction. Virtual charter instruction is public school instruction with teachers who are going to plan your curriculum, grade and assess your work, prescribe content, report outcomes and evaluate the effects of the instruction. So they have to do those specific provisions that teachers are required to do, so that you aren't putting this all into parents' laps and saying, okay, this is all for homeschooling. So I actually had a situation where this came up in DPI. It was a difficult decision, or a difficult matter. I would make these other, I would include these other provisions with regard to virtual charter schools. As a virtual charter school, you have to provide educational services for a certain number of days, and then you have to take certain steps so that, you know, parents know who's on your board and things like that. So I would include these in your contract because I think that these are provisions that if you're a district authorizer, you're going to want to ensure that your virtual charter school is following these. I would address special education in your contract. When you are a district authorized charter school, the district is what's referred to as the LEA, the local educational agency, that is ultimately responsible for ensuring that students with disabilities who are eligible for special education get a free appropriate public education, that students who are eligible under Section 504 of the Rehabilitation Act receive accommodations and related services that are required. But sometimes it's unclear, and I've had it come up with the virtual charter schools, who's providing those services. So is the district going to provide special education services? So if you are a charter school and you have a student who has an IEP or an individualized educational program, is that student going to go over to a district school to receive whatever services are required? How is that going to be set up? If the charter school is providing it, how are those IDEA funds or those federal funds that districts get specifically to provide special education, how are they going to get to your school? What's that delineation going to look like in terms of making sure that those IDEA B funds flow to the school that's actually providing the services? Charter schools under 2X and 2R are the LEA for purposes of IDEA. So if you're a 2X or a 2R charter school, you are the responsible entity for providing special education. So you need to have someone in your organization, in your 2X or your 2R charter school, who's really familiar with special education law and knows what the responsibilities and obligations are under those laws. Special education related services, yep, this just kind of goes through the same sort of thing. This talks about disposing of property. So if you buy property if you're a district authorized charter school and you buy property and you have bought that property with funds that have come from state aid from the district, you're going to want to include a provision in here that says, okay, what if you don't need the property anymore? Where does it go? Is it your property? Well, it was bought with state aid. Do you give the district the opportunity to first take the property back? What if you've bought property with money that your PTO has raised? So your parent-teacher organization raises $50,000 so you can buy all new computer equipment. Well, if now you're getting rid of that computer equipment, you want to make sure that it's clear in here that you can dispose of that property differently than you would have to if it was property that was purchased with funds that came directly from the district. So that's just an example and a suggested provision, but I would definitely have a provision that deals with how do you dispose of property that you have purchased. A provision that deals with background screening. I would talk about, I would have a provision in there that deals with that. This is a provision that actually is required in your contract, and I'm sorry if this is not clear from the handout, but you have to indicate in your contract how much, as in a district authorized contract, how much a district is paying a charter school. And you can set that payment up in a lot of different ways. Most of the time, what I have seen in charter contracts is that a district will and a governance board will agree on a certain percentage of the per pupil allocation. So if the per pupil allocation that comes from DPI to districts every year is $7,000 per pupil, I have oftentimes seen where a charter school governance board and a district will agree that the governance board will receive 87% of that per pupil allocation, recognizing that maybe that other 13% goes to cover the administrative costs of the district in running the charter school. Make clear as to whether or not that per pupil allocation, if you're an instrumentality of the district, if that per pupil allocation is going to be given to you separate and apart from employee salaries, or if they're going to say, okay, we're going to give you 87% of the per pupil allocation, and now that 87% is going to be reduced with each employee we pay for, and those employment costs. So just be sure that you know and address that process in the contract. This just is a little bit more on that. In addition on that is saying set up an operating budget, and kind of gives you some provisions to talk about the fact that the Charter School Governance Board would set up an operational budget. And then section 5.10 is, okay, you've now set up your operational budget. You've told the district you agree to 87% of per pupil allocation. Well, now we just had a huge flood, and the facility we're in has to be, we're going to have to go in and do a bunch of renovation and repairs to it. That kicks us way over what our operational budget is, and we have this huge amount of expenditures, and that 87% is not going to cover our expenditures. 5.10 just gives you a provision to deal with unexpected costs, unforeseen operational expenses or capital expenditures, or a year where your enrollment dips so far you're not getting enough funds in to operate. So kind of just some ways to deal with that and make sure that you have provisions in the event that happens. Setting support services, assessing fees. You can assess fees, and DPI has a good bulletin on this in terms of when it's okay to assess fees, but you have to be sure that you follow that in terms of when you actually can assess fees to students. Are you providing transportation or not providing transportation as a district to charter school students? Most of the districts I see, frankly, if your district's authorized, they don't provide transportation. It doesn't mean you can't, but you want a provision in there to talk about that. The school lunch program. Some charter schools have a program where they're growing their food, and they're, farm to table, and their lunch program is not included. Be sure you have talked about that and included provisions in your contract that make clear, does that per pupil allocation include lunch for your students? Does it not? Are you going to have to pay separately for that? How does that work in? Visits and inspections into the charter school from the superintendent or the authorizing entity. Student records, a provision to deal with student records and how those are going to be maintained. When you have student records, and depending upon what kind of records they are, they may be health records of a student that have come to you from a doctor, they may be special education records, they may be general progress records or disciplinary records. Federal law requires that those be kept for different amounts of time. They have different disclosure requirements with them, and confidentiality rules. So a provision in there that just says you are going to comply with all applicable laws regarding student records. A code of, this is really big, a code of conflict, and I just mean in terms of the font, all of a sudden it's large. I would include having a conflict of interest or a code of ethics provision. If you are a 501c3 organization, if you're a governance board and you're a 501c3, to get your 501c3 or federal tax exempt status, you're going to have to provide a code of a conflict of interest policy to get it. If you are not a 501c3 and you don't have a conflict of interest policy, I would suggest developing a conflict of interest policy. You can really just mirror the code of ethics for public employees under 19.41. And if you look at that provision in the statute, you will see there is a very specific conflict of interest policy or a code of ethics policy that's in the statute. Operation or management contracts, if you're going to have operational or subcontracts with other entities, and even if you don't know that you are, I would include some provisions in here that talk about, is there any review by the authorizing entity over those contracts, and what does that review look like? Do they have the ability to say, no, we're not going to allow you to enter into a contract with that religious organization, even though you're getting secular materials from them? Or how long do they have to review that potential contract and to approve it or not approve it? So this provision specifically kind of sets out a process by which you put in place to deal with your subcontracts as a school. Performance evaluations, I would address these in contracts. How are you going to review how is the district or the authorizing entity going to review the performance of the school so that it doesn't get 3 or 4 years down the road and you're 1 year before the contract ends and all of a sudden, oh my gosh, really the students aren't performing what we thought they were going to be performing to, and now we're pretty far into this, and what do we do? So I would set that out. Notices, reports, and inspections. I would talk about, are your agendas going to be posted? Are your meetings? School districts that are, or charter schools that are district authorized charter schools, we have taken the position in our firm that they are subject to the open meetings law. And the open meetings law has very specific rules in terms of noticing of meetings, how you handle those meetings, when you can go into closed sessions, when you can, when and where you vote on matters. And so you're going to want to have a provision in there that deals with it. 2X and 2R, I would say, I think there's a good argument to be made that they are subject to the open meetings law. I haven't done that analysis yet, but I think that's a provision to consider as well. You want to have a provision in there that says, hey, look, if you get an OCR complaint or a complaint from the Office for Civil Rights, or a parent brings a complaint with the Department of Public Instruction based upon special education, or we are being sued because of X, you're going to want to have a provision that says, if that's the case, you have to promptly notify the authorizing entity or the district that you have received this. You can't sit on it and try to deal with it. You have to promptly notify them so that the district can get involved. Events of default. So this is the revocation by the district. I won't go through all of these. The statute has certain provisions that says a district may revoke a charter contract if these events occur. We have kind of tweaked that and made that a little bit broader and included additional provisions, and you can take a look at those, these provisions in here. Then I've included in the contract procedures for revocation. So what are those procedures? You can't just say, sorry, we're revoking the contract, we're done. Well, you've got 100 students in this charter school. When is it ending? Where are those students going? Who takes charge of it? What happens with the finances? So we've, in this section 8 or Article 8, we've really tried to set forth a pretty comprehensive termination or revocation procedure that you can follow in terms of if certain events of default happen. And that goes with termination by both authorizing entity and termination by the governance board. Then I'm just at technical provisions, and then I think I'll just open it up to the last couple if anybody has any questions. Technical provisions you're going to want to have in there. One of them being, you have to have in there the term of the contract. It cannot be longer than 5 years. So if you say this contract is implemented on June 5th, 2020, it can't go until June 10th, 2025. It has to be within a 5-year period. So the term cannot be longer than 5 years. You may want to include in there whether there are possibility for renewal and what that would include. You may want to include a term of a contract that's shorter than 5 years. Doesn't have to be, it just can't exceed 5 years. And then these are just very technical provisions that are in contracts. It talks about that this contract is the entire agreement. The superintendent and the board president of the Charter Governance Council may have sat down to dinner the night before and agreed on a whole bunch of other things, but those are not part of this agreement. Whatever is in this agreement is the entire agreement. And just some other provisions in there that are helpful. Notices, where do notices have to go? I'm a district authorizer, and I say, okay, we see that an event of default has occurred with the governance, with the charter school. We're going to give them notice that they have 30 days to cure that. Well, where does that notice have to go? This makes very clear. If it says it has to be personally delivered to the president of the charter school governance board, unless it is, those 30 days don't start. So just be clear about those things. And then some other provisions you might want to consider adding some appendices to the contract. What is the proposed operating budget? Does the charter school have a parent-student handbook? Is there an employee handbook? Are there policies that are different than the authorizing entity? What's the calendar, leases, operational or management contracts, subcontracts, your certificates of insurance, all things that you may want to consider and require as part of the contract. And then the signature piece. You're going to want to have the governance board, whoever has authority for your governance board under your bylaws, sign the contract, and the district board of education, the secretary probably, and the clerk, or the president and the clerk. But you're going to want to have the signature pages obviously as well. You can take a look at these FAQs. I just included these since these came from Works FAQs, and we've already talked about this one. So the one thing that I will say before I turn it back over, Sarah, is I am happy to take questions. So if you all have questions and you're looking through this and you're saying, that was a lot of information on 60-some slides, and she went through it really quickly, you can feel free to call me. I can't give legal advice to non-clients, but I certainly can talk through it if you're not understanding what has to be in the contract or what that means in the law or the provisions, the suggested provisions that I've talked about. So I gave you my office number and also gave you my email.
Thank you so much, Tess. Holy cow. And you were worried that you wouldn't fill the 2 hours, and I'm just sitting here going, oh my gosh, we're flying.
Yeah. I knew that I would fill the 2 hours. I was trying to see if it really 2 hours or if I was supposed to just really fly through things. Sarah, the one thing that I didn't mention and I didn't talk much about are the contract benchmarks. Everything that I have talked about in the contract, that I started with the benchmarks and revised and went through these benchmarks, identifying what is absolutely required and what is suggested. So when you are looking through your contracts, if you already have a contract, I would just make sure, or you're looking to draft one, I would make sure you're going through these benchmarks and ensuring that you have the required pieces of it and that you're considering some of the other ones. It's a helpful checklist. Yeah.
And I'm just going to put a quick plug into sending questions to Tess or calling her is fine, but Tess is probably just going to record it for me so that I know kind of which districts are coming to her, because I want to be in the loop. The other way you can do it is email me or fill out the form that's on our homepage, and it's called like a request for technical assistance, and all those questions go to Tess. But if you do it that way, we can add it to our frequently asked questions page, and then other schools can benefit from it too. Without your name wouldn't be attached to it. We just you know,
it's actually a really good point, Sarah. I should have put that on here. That's probably a better way to do it.
And I can show it too. So I'm going to stop recording so you all are free.